Ted, I'm offering you a terrific deal. This case is worth millions. The sexist manager for your scumbag corporate client fired my plaintiff because she was a woman. The jury will want to skin the manager alive.
Not so fast, Erin. Your client was late to work at least once a week. The manager fired her because she was irresponsible.
Oh, really? What about the fact that he only fires women? Your manager fired 10 workers during the last 2 years. Every one of them female. And everyone moving up the promotion ladder. Your manager's department has fewer women than a Tibetan monastery.
Look, Erin. I admit our manager has been a little, old-fashioned in the past. But you're not representing those other women who were fired. And Rule 404 prohibits evidence of those other acts. It's all propensity evidence.
Propensity, my foot. Rule 404b allows other act evidence to prove motive, intent, plan, or absence of mistake. Take your pick. You just told me you plan to dispute discriminatory intent. That means we can introduce evidence of prior bad acts to show the manager's intent.
So you plan to prove 10 discrimination cases instead of just one? Make my day.
I don't have to prove 10 cases. Under Rule 104b, I just have to persuade the judge that a reasonable jury could find, by a preponderance of the evidence, that the manager fired those other women. That's the Huddleston standard. Jump that low hurdle and I'm home free. Once the jury hears about all of those other women starving on the breadline, they'll have some tar and feathers for your client.
Don't get too excited. Tar for the gander is tar for the goose. I can use the same rule to show that we fired other employees for lateness. 404b allows evidence of other acts to show good intent, as well as bad.
Good intent, my elbow. Don't forget the other evidence we have. We'll be presenting testimony that your manager called my client boobsy. And he repeatedly asked the women why they were taking good jobs away from men during a recession. He could hardly open his mouth without saying something sexist.
Surely you're not going to argue that the manager's conduct is habit evidence under Rule 406?
The sexism was so automatic that I'm tempted. But, no, courts rarely admit voluntary acts with moral overtones as habit. These are just more acts to confirm intent under 404b. We'll also use this evidence to support our hostile climate claim.
Once again, the goose boils in the same pot as the gander. We have Facebook pictures of your client flaunting herself at topless beaches. And she had a rather, liberal approach to mating. We'll rebut your hostile climate claim by showing that your client welcomed any sexual comments in the workplace.
Welcomed, my ass, ankle. Haven't you heard of the Rape Shield Law? 412b2 applies to civil cases. And it imposes a reverse 403 test to evidence of a victim's sexual behavior or predisposition. In hostile climate claims, most courts exclude evidence about the plaintiff's behavior outside the workplace. Where have you been for the last 10 years?
These rules seem pretty one-sided to me. Character evidence about my client gets in. Character evidence about your client stays out.
Sorry, Ted. I guess Mother Goose finally outsmarted the gander. But my client will accept $500,000 to make this go away for your client. I'll give you an hour to get back to us.